versus Albert Hemmer Hicks Jr. Case numbers SP 1442547, counts 1, 2, and 3. SP 144.
Right from the very first exchange, the red flags start flying. When a judge asks you to unmute, the correct answer is usually something like, "Yes, Your Honor," or even just, "Sorry, one moment." But instead, the courtroom gets hit with a cryptic mumble, "Maybe sovereign." And that tiny phrase tells the judge everything he needs to know. Sovereign citizen ideology isn't new. Judges recognize the signs instantly. The refusal to follow simple instructions, the vague attempts to distance oneself from the legal system, and the belief that labeling yourself sovereign somehow exempts you from court authority. To the judge, this is déjà vu, and it only gets worse from here.
27651. And it looks like the rest of this stuff. Then I have SP 1500871, and it looks like the rest of this stuff he's already entered a plea into all this stuff.
No, sir. No plea.
Well, that's not what it says here, sir.
I represent myself. I couldn't enter the plea. I never plea. You can check my record. I never plea.
Oh, maybe I found you guilty then. Yeah.
No, I haven't been. Matter of fact, I came inside there personally a week or so ago. And the young lady, the security officer, came out and said that I'm supposed to report today.
No, this is on some old stuff. All right.
I never entered the plea.
So do you not want the representation of counsel?
No, thank you.
Okay. There you go, Mr. Take, that's your first break of the day, Mr. Soroki, you know what I mean?
Judge.
At this point in the hearing, the judge is trying to keep the process simple. He just needs the defendant to confirm identity, acknowledge the charges, and move forward. But with sovereign citizens, even confirming their name becomes a 10-minute argument. They insist they do not consent. They ask if the judge is operating under common law, or they claim they are the living man, not the corporate fiction. Judges try to stay professional, but after hearing the same script for the 100th time, you can practically feel the irritation leaking through their calm tone.
I know how to deal with everybody. So I said, I know how to deal with everybody, any type of client.
Yeah, I know, but he doesn't want it.
Right,
So
I understand.
We can't force it on him.
Yeah.
No, I understand.
Yeah. So you can
Take it as
so Mr. Lee, today is the date and time set for a show cause. That's for purposes of arraignment, sir. We'll do it like this. I'll enter a not
Are you
guilty.
talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to follow the prompts on it.
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
If you've watched enough court cases, you know judges always try patience before punishment. They start by explaining the process, then by correcting misunderstandings, then by issuing warnings. But sovereign citizens test that patience at every turn. They interrupt, they lecture, they demand irrelevant documents be accepted into the record. And when the judge refuses to play along, their frustration grows. Harrison is following that exact pattern, small defiance at first, escalating into full obstruction if not controlled. The judge knows what's coming. He's been here before.
Should be down with area code 929.
Mr. Hicks, for purposes of arraignment, I'm going to enter a not guilty plea on your behalf and give you a $0 bond, all right?
That would be practicing in front of the bench.
It's the same process.
Say that again.
I object. That would be practicing from the bench, practicing law from the bench. You will have to recluse yourself if you hold on.
Well, I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed, if it pleases the court.
Deny. What basis?
You
what
haven't
basis?
even let me tell my grounds.
All right, basis. Give it to me.
For one, a ticket is a bill of attainder.
One reason these cases go viral is the contrast between the professionalism of the judge and the wild unpredictability of the sovereign citizen. Judges rely on logic. Sovereign citizens rely on catchphrases. Judges use statutes. Sovereign citizens use YouTube videos. Judges handle real consequences. Sovereign citizens cling to imaginary loopholes. And when these two worlds collide, it creates moments that are equal parts unbelievable and strangely compelling, like watching two people speak entirely different languages in the same room.
Article 1, Section 9, Clause 3 of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You can have a written assistance
All right, let me
to
stop.
equity that transmitted into law penalties.
Let me stop you right there. Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really, really, really bad, and we can't get that on the, turn your video
I
off.
understand.
Maybe turn your video off. That will help. Let's see.
At this stage, the judge is already bracing for procedural roadblocks. Will Harrison refuse to enter a plea? Will he claim the court lacks jurisdiction? Will he say he's appearing under duress? Every sovereign citizen hearing includes at least one of these tactics. And judges, especially ones who've dealt with these defendants before, prepare mentally for the moment they must assert firm control over their courtroom. That assertiveness is coming.
All right,
Is it
try
better?
it now. Try it now. Let's see. Go ahead.
Did you hear what I said?
Yeah, I'm listening.
Okay. Article 1, Section 9, Clause 3 of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You cannot have a writ of assistance that has civil equity that transmits into law. Number 2, there is no sworn statement from an injured party. Number 3, the officer did not even sign the ticket. That's under law of penalty of perjury. I'm asking that all of these be dismissed.
All right, House, do you want to proceed?
People often ask, why don't judges simply dismiss these defendants or ignore their antics? Because real cases are on the line, real charges, real victims, real legal outcomes. A defendant refusing to participate doesn't halt the system, it just makes their own situation worse. Harrison may believe he's rising above the law, but the judge knows he's only digging himself deeper, and soon, the consequences will reflect that.
That's your declaratory judgment?
I'm going to deny the motion. I deny the motion.
Okay, let's go to court.
Trial?
It don't matter, because I don't understand how y'all run y'all system. Y'all practice against the law. I'm a common law.
Well, read the court rules, and you'll learn a little something.
The court rules go against the law. Y'all practice against the law, against the Constitution. I'm all common law.
All right. Well, we're beyond that.
Okay.
All right.
So you say. So are you going to prosecute this, or somebody else going to prosecute it?
Stop. Let's not keep going. All right. You want a trial date, or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to let's give him a jury trial date.
Jury trial.
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay. Scamming. With a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your respect for the court, but I asked the questions. I told you to read the court rules.
March the 5th. Let me check and see.
The court rules. What jurisdiction are you trying to charge?
Is March the 5th a good date for you, sir?
No.
Okay.
June the 11th is going to be the jury trial date.
June the 11th?
June the 11th. So let's put your final pretrial date will be, let's see, put that a day before. That way, that'll be the date we'll argue motions on June the 10th. May the 24th will be your motion, and now these
May 24th.
May the 24th, and the city will have 7 days to respond. So the response to the motion will be due by May the 31st.
I appreciate you, Your Honor.
All right, have a very good day, sir. Best of luck to you.
I just did. Thank you.
Good morning. You have a final pretrial set for June the 10th, and you have a trial date. You have a final pretrial set for June the 10th, and a jury trial date set for the same day. Okay, that's not correct.
By now, everything has spiraled. Contempt fines or procedural denials aren't arbitrary. They're tools to maintain control. Every refusal, interruption, or mockery chips away at the judge's patience. Hicks reacts emotionally, and the judge responds proportionally. This cycle shows why defiance never wins. Each outburst only strengthens the legal authority against him. If you were in the judge's seat, would you keep giving chances or enforce order immediately? This is a lesson in courtroom psychology as much as law.
Yeah, you did.
Hold on one second. Let's get the date straight.
I'm not here for that.
What are you here for, sir?
The slip says for Jonathan Reeves.
Jonathan Reeves.
Yes.
I don't know anything about a Jonathan Reeves. Let's see. Maybe. I don't know anything about a Jonathan Reeves.
Well, I motion for this case.
Are you Mr. Hicks? Are you Albert Hicks?
Yes, I am.
Okay, so we're going to get you your dates, and that Jonathan Reeves.
I already have my dates. I talked to you last week, remember?
I think it's correct.
I have June the 10th and June the 11th.
Very well. Okay, we'll see you back on those dates, sir.
But this matter right here with this Jonathan Reeves.
Well, what does Jonathan Reeves have to do with you?
That's what I'm here for court for today. I'm making a personal special appearance for this.
Okay, I don't know. Who is Jonathan Reeves? Do you know who that is? What does it say on that? Because it sounds like it may be Jonathan Reeves may have stayed at that address at some point and left. I don't know.
Notice Hicks's repeated failure to track court dates. He shows up early, misreads notices, and expects the courtroom to adapt to him. This is classic sovereign citizen behavior. The law exists around them, not for them. Judge Perkins, however, doesn't negotiate on schedules. He enforces the rules, consolidates hearings for efficiency, and ensures legal procedures proceed regardless of Hicks's misunderstanding. It's a clear demonstration of judicial authority versus self-styled legal independence.
That's all
That's why
about.
I'm asking that this case be dismissed. The case is SP 15008721.
SP 15008721. Okay, that's not
Okay.
Jonathan. Okay, Jonathan Reeves is the officer that apparently wrote the ticket.
And where?
And that's scheduled for the final pretrial on, I see where he's here today. It says scheduled for pretrial today. But that's all gonna be handled on the 11th of, Jonathan Reeves is supposed to be here on the 11th of June, on the day.
I was not notified. 11th of June.
Yeah.
How is he going to be here on the 11th of June? And I have Spidell on the 11th of June.
You have a couple of different officers, obviously.
Jonathan Reeves and Spidell has nothing to do with each other.
Well, we're just consolidating. We're having all of them.
Why would you do that against my will? Why would you just do that?
I'm doing it because of the judicial economy, sir. So
I'm challenging that one.
Okay, then write a motion, and we'll rule on it. But it's all in the same. We're all going to do it on the same day.
You didn't ask.
When Hicks questions judicial consolidation, he frames it as rights infringement. But it's actually standard procedure for judicial economy. Judges consolidate related cases to avoid redundant hearings and streamline evidence. This is not a personal attack. It's procedural efficiency. Defendants often misinterpret process as bias. Perkins handles this calmly, showing the difference between emotional reaction and professional judgment. The takeaway: law is procedural, not personal.
Charge. I get to do shit you don't get to do. It's part of the black robe, okay?
I don't have to ask.
You didn't ask me that. You just arbitrarily did it. That's not right. That goes against my rights.
All right. Well, you can put it in a motion, sir.
Well, the whole thing is, I don't know what y'all doing down there, but you are totally infringing on my rights.
Okay, well, file a motion, sir. That's how you speak to the
Why
court.
would I have to file a motion when you infringed on my rights? And I'm saying it right here, right now.
That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right?
My honor, please. I'm bringing up valid litigation for this. I don't know what y'all doing. Y'all can't do anything without my permission. I'm not a ward of the state.
Mr. Hicks.
I'm an unfranchised common law free man.
Mr. Hicks. All I ask you to do is you can file a motion. You can put all of that stuff in the motion.
Yeah, so y'all, so you can come back and say motion denied, right? Like you did last time.
Well, that's my discretion. If I don't feel that if it doesn't meet the criteria of the law, then that's what my
What jurisdiction are we?
I'm not going to answer this question, sir.
Oh, you're not going to answer the questions? Then I would like to know your status.
You don't ask the questions. I ask the questions. That's how.
Oh, you're going to play like that. What is your status? I am a common law free man. What is
Even after all disruptions, the judge proceeds to finalize pre-trial and trial dates. This reinforces a key lesson. Courtrooms are structured, rules-based environments. Misunderstanding or ignoring them doesn't halt the process. It only leads to predictably negative outcomes. Every defendant should take note: preparation, respect, and clarity matter far more than theatrics or pseudo-legal arguments.
over? Okay.
So let me finish, and I'll let you speak. If you're not gonna do it that way, you're either gonna get out the room or you're gonna be in. I'm gonna lock you up. All right. So today is the date and time set for a pre-trial, and this pre-trial, the officer is not required to be here for a pre-trial. The pre-trial date is set in order for you to get an offer to either settle up the case, or in this case, we're setting a trial date. You have dates already set. The date motion due is going to be on May the 24th, 2024. The response to that motion, if the city chooses to respond, is going to be on May 31st, 2024. Your next court date that you need to be present is going to be on June 10th, 2024 at 8:35, with the jury trial set the next day on June 11th, 2024 at 9:35. Okay? Now, I'll let you speak, and we're going to end
Is
that.
all of this on record?
This is all on record.
Is all of this on record?
Yes.
Okay, please send the information to my home.
In the end, Judge Perkins remains calm, methodical, and firmly in control. Hicks's self-representation and pseudo-legal claims collapse under real procedural scrutiny. The final ruling stands, the trial dates are set, and the lesson is clear. Courtroom authority is real, patience has limits, and chaos never triumphs over structure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.